This is Constitutional Rights in Black and White.
In 1961, using contraception was a crime in Connecticut. Specifically, Connecticut law provided that any person who uses any drug, medicinal article, or instrument for the purpose of preventing conception shall be fined not less than $50 or imprisoned not less than 60 days, nor more than 1 year. Estelle Griswold was the executive director of Planned Parenthood of Connecticut. Together with Dr. Lee Buxton, a professor at Yale Medical School, the two opened a birth control clinic in downtown New Haven. The clinic served many in the community, including those who could not afford private physicians. There, married couples could get the counseling, medical care, and access to birth control that was elusive for so many. 10 days after opening the clinic, Griswold and Buxton were arrested, charged, and then convicted under the Connecticut law. Their case went to the Supreme Court, where they argued that married couples have a constitutional right to privacy that includes the right to use contraception. On this ground, the Connecticut statute that made the use of birth control a crime was unconstitutional. The Supreme Court agreed. The present case concerns a relationship lying within the zone of privacy created by several fundamental constitutional guarantees. The marital right of privacy is older than the Bill of Rights, older than our political parties, older than our school system. But wait, said the lawyers representing Connecticut, you just made that up. There is no right to privacy in the Constitution. Yes, there is, said the Supreme Court. The Bill of Rights contains numerous zones of privacy, both explicit and implicit. The right of association contained in the penumbra of the First Amendment is one. The Third Amendment and its prohibition against the quartering of soldiers in any house is another facet of that privacy. The Fourth Amendment explicitly affirms the right of the people to be secure in their persons, houses, papers, and effects against unreasonable searches and seizures. The Fifth Amendment enables the citizen to create a zone of privacy. Maybe so, said Connecticut's lawyers, but none of those privacy rights has anything to do with birth control. Oh, yes, they do, said the Supreme Court, because they contribute to our broader understanding of the fundamental right to privacy. These specific guarantees in the Bill of Rights have penumbras formed by emanations from those guarantees that help give them life and substance. Marital privacy might not be expressly included in a particular amendment, but its existence is necessary in making those express guarantees fully meaningful. Without it, we wouldn't really have meaningful privacy at all. After all, would we allow the police to search the sacred precincts of marital bedrooms for telltale signs of the use of contraceptives? The very idea is repulsive. Wow, said the Connecticut lawyers. This is extreme judicial activism. You're just imposing your own personal moral views of what the law should be. But it's the legislature's job to make the law, not the courts. Mostly yes, said the court. The state has broad power to regulate the manufacture and sale of contraception, but constitutional rights limit that power. Connecticut may not regulate the use of contraception by means which sweep unnecessarily broadly and thereby invade the area of protected freedoms. The criminal statute is unconstitutional. Griswold versus Connecticut is famous for its articulation of the right to privacy. This is the case that launched us into the era of constitutional protections for intimate and personal choices. The court's analysis of privacy, due process, and intimacy provided the doctrinal building blocks for the universal right to contraception, not just for married couples, a woman's right to choose an abortion in Roe versus Wade, the right to same-sex intimacy in Lawrence versus Texas, and the rights of interracial couples and same-sex couples to marry. Today, 60 years later, the Supreme Court is now shaking this entire constitutional foundation, which makes it even more urgent to understand Griswold. So let's read the case. The Griswold case was part of a long-standing campaign by Planned Parenthood and many other advocates to challenge the widespread criminalization of contraception, abortion, and other forms of family planning in Connecticut and other states. In order to bring the case at all, Estelle Griswold had to overcome prior decisions holding that third parties, like her and Buxton, could not vicariously assert the constitutional rights of their patients. Here, however, Griswold and Buxton were prosecuted directly for aiding and abetting the illegal use of contraceptives. That was enough to confer standing in Griswold. But the court actually went further. analogizing to other cases where litigants like teachers and employees were permitted to raise third-party claims because their rights were inextricably intertwined with the rights of third parties like students and employers. This means that in addition to its holding regarding the right to privacy, the Griswold court also laid the foundation for third-party standing, where medical providers assert claims on behalf of their patients, a doctrine that continues to be used in other reproductive rights cases. The heart of Griswold's claim is that the Constitution confers on married couples a substantive right to privacy that protects, among other things, their choice to use birth control. In order to determine this question, the court surveys and interprets a long line of constitutional decisions in which it previously found various forms of constitutionally protected privacy rights, even though those precise entitlements were not specifically enumerated in the Bill of Rights. In Pierce versus Society of Sisters, for example, the court found that the First Amendment confers a right on a parent to, quote, educate one's children as one chooses. In NAACP versus Alabama, the court found a protected, quote, freedom to associate and privacy in one's associations. This right meant that Alabama could not require the NAACP to disclose the names of its members. In West Virginia versus Barnett, the court found a right not only of association, but a right of belief. It struck down a law requiring public school students to salute the American flag. The challengers were Jehovah's Witnesses, who oppose saying the pledge on religious grounds. Specifically, the court noted that while the right of association is, quote, not expressly included in the First Amendment, its existence is necessary to making the express guarantees fully meaningful. Notice how the invocation of these cases in Griswold is doing double duty. They recognize the prospect of unenumerated rights, of course, but they also speak to the effort to limit the state's impulse towards homogenizing the citizenry. Both Barnett and NAACP versus Alabama spoke directly to and disapprovingly of government efforts to compel conformity among its citizens, including politically unpopular groups like the NAACP and the Jehovah's Witnesses. That broad understanding of liberty also motivated the court's disposition of Griswold. In identifying a right to privacy that might allow the citizens the opportunity to be non-conforming in certain aspects of their lives, the Griswold court anticipated critiques that the decision was merely the court's effort to invalidate the law merely because the justices objected to it, a return to the discredited Lochner era, so named because the court in a 1905 decision invalidated a progressive labor law on the ground that it violated the unenumerated freedom of contract. The Griswold court dealt with the charges of Lochnerism explicitly, insisting that it did not sit as a super legislature to determine the wisdom, need, and propriety of laws that touch economic problems, business affairs, or social conditions. This law, however, operates directly on an intimate relation of husband and wife and their physician's role in one aspect of that relation. Griswold is also an important template for understanding constitutional interpretation. The court writes that specific guarantees in the Bill of Rights have penumbras formed by emanations from those guarantees that help give them life and substance. Various guarantees create zones of privacy. The Griswold court derives its understanding of privacy from a broad array of constitutional rights, including the Third, Fourth, Fifth, and Ninth Amendments, each of which protects a different kind of privacy. Indeed, many of the privacy arguments made by the ACLU in its criminal procedure cases were subsequently translated and repurposed by ACLU lawyers for use in the Griswold litigation. In other words, big ideas like privacy or speech or liberty should be interpreted by reference to our entire constitutional scheme, not just to isolated text. Another key point in the Griswold decision is the line it draws between different forms of state regulation, both permissible and impermissible. The state retains its right to regulate the manufacture or sale of contraceptives, but a governmental purpose to control or prevent activities constitutionally subject to state regulation may not be achieved by means which sweep unnecessarily broadly and thereby invade the area of protected freedoms. This is a central feature of individual rights doctrine. The constitutionality of state regulation will turn not only on its subject, but also consider its scope and intrusiveness. The court also recognizes the far-reaching implications of criminalization and the privacy invasions that it permits. Would we allow the police to search the sacred precinct of marital bedrooms for telltale signs of the use of contraceptives? No, says the court. The very idea is repulsive. Here, the court is actually echoing the wording of a Planned Parenthood advertisement that featured drawings of marital bedrooms with police officers lurking underneath the beds. There were several concurrences and dissents in this case. We will focus on just a few of their aspects. Justice Arthur Goldberg concurred in the decision, agreeing that the Constitution confers a right to privacy and finding additional support for such a right in the Ninth Amendment, which reads, "The enumeration in the Constitution of certain rights shall not be construed to deny or disparage others retained by the people." Goldberg reiterated James Madison's view that the enumeration of certain rights was not intended to exhaust the basic and fundamental rights which the Constitution guarantees to the people. Goldberg also invoked the specter of totalitarianism in Connecticut's effort to control intimate family decisions. The threat of Nazism and fascism were only 20 years in the rearview mirror here. As the only Jewish member of the court at the time, Goldberg was particularly well positioned to remind his colleagues of the dangers of government intervention into intimate life. Justice Byron White concurred in the judgment as well, highlighting the class implications of the contraception ban. As he noted, the true impact of the law was borne disproportionately by the poor and disadvantaged, those without either adequate knowledge or resources to obtain private counseling, access to medical assistance, and up-to-date information in respect to proper methods of birth control. Justice Hugo Black dissented from the majority opinion. While asserting that the law is every bit as offensive to me as it is to my brethren of the majority, he rejected the idea that the Constitution contains a right to privacy at all. He argued that the lack of specific enumeration is fatal and that the right to privacy reflects an unacceptable form of judicial activism. Justice Potter Stewart likewise dissented, calling the law uncommonly silly, but agreeing with Black that the court lacked authority to strike it down. This approach was later reprised by future justices, including Justice Clarence Thomas, who dissented from the majority in Lawrence versus Texas, even while calling the challenged Texas sodomy prohibition uncommonly silly. Justice Stewart ends his dissent by arguing that the constitutional way to take this law off the books is for the people of Connecticut to persuade their elected representatives to repeal it. But such things were easier said than done. Birth control advocates tried for years to repeal the law, and their efforts were repeatedly thwarted by the Catholic Church. Indeed, whenever a repeal bill appeared for a vote, local priests would instruct their parishioners to contact their representatives to vote to keep the law on the books. This powerful kind of interference with the democratic process is precisely why individual rights so often need protection from majoritarian processes. Griswold is most famous for its articulation of the constitutional right to privacy and its support for personal and intimate choices. But we'll end by noticing that Griswold could have been decided on entirely different grounds, based on principles of sex equality. It's worth noting that the challenge law in Griswold prohibited the sale and distribution of contraception, the kind of oral contraceptions that women use for the most part. The law made no provisions prohibiting the distribution of other kinds of birth control, including prophylactics, a method of birth control that was primarily used by men. Now, access to birth control has allowed women to facilitate their personal, economic, and social lives, something that would be heavily limited without access to reproductive control. Access to birth control has permitted the family and professional planning that's been necessary for many women to support their careers, to determine their choices of partner, and to determine the timing of various life choices. Previous cases had raised this equality argument, but the court never reached them. And then in Griswold, the court changed the subject entirely, locating the right to contraception in privacy rather than equality. This choice has come back to haunt us. In 2014, in Burwell versus Hobby Lobby, the Supreme Court permitted religious employers to avoid paying for birth control insurance coverage for their female employees. In dissent, Justice Ginsburg raised equality grounds, pointing out that the ability of women to participate equally in the economic and social life of the nation has been facilitated by their ability to control their reproductive lives. In 2022, in Dobbs versus Jackson Women's Health Organization, The Supreme Court entirely reversed the course it began in Griswold. It overturned Roe versus Wade, finding that there is no right to an abortion in the Constitution at all, and leaving the decision about whether and how to criminalize abortion to the states. The dissenters in Dobbs again made the equality dimensions clear. A woman's right to decide for herself whether to bear a child protects the liberty and equality of women. Perhaps if the Griswold Court had recognized the equality dimensions of its decision in 1965, we might today have stronger protections for women altogether.
Deep thanks to Professor Melissa Murray, who is the Frederick I. and Grace Stokes Professor of Law at NYU Law School. She's an award-winning scholar, a nationally renowned expert in family law, constitutional law, and reproductive rights and justice. She's also co-founder of the important and wildly popular podcast about the Supreme Court, Strict Scrutiny. We're very lucky that she took the time to share her analysis with us.